Hi, I'm Ben Sessions. What I've tried to do in these videos is give you some sort of informal practice tips and ideas about what to expect in different areas of criminal defense law. The one thing that I'd like to talk to you about today is how it is that I go about preparing clients for bond hearings. Bond hearings generally take place in one of two different ways. Either they're really informal where the judges don't really hear evidence and the lawyer just proffers what it is that the bond factors that the judge should consider in setting a bond for the client, or the bond hearings can be really formal, and typically those involve witnesses being called to actually testify to the four bond factors which are outlined in connection with this video. You can go there and review what the actual factors are, so I'm not going to go over those right now. What I'd really like to do is talk to you about how it is that I like to approach bond hearings and what it is that you and your family, or as a lawyer, what it is that you should really be thinking about. I tend to believe that it's really advantageous for our clients in the vast majority of cases to actually have witnesses called. I know that it's nerve-wracking for most people to get up and testify about the different factors that would come into play in the course of a bond hearing. But it's really, really helpful for judges to hear about how it is that people know your client, how it is that your client is connected to the jurisdiction that the crime is actually pending in, or how it is that they're connected to the state of Georgia, and what type of financial resources it is that the person has. Because a lot of times judges just don't know, and it doesn't mean anything for a lawyer to stand up and say, well, we really don't have a lot of financial resources for our client to post a bond in this case. It means a lot more for the person's wife or the person's mother or the person's aunt to sit up and say, you know, Ben is a good person. He's worked a blue-collar job all of his life. As a family, we really don't have much in terms of resources to come back to. We don't own any property. All of our family is all working-class people, and he supports his two children. That means a lot more than for a lawyer just to stand up and go, well, this person doesn't have any money to a judge. It can be a lot more compelling for actual live witnesses to testify during the course of those hearings. So I tend to believe that if you can put together a fairly consolidated list of people, but have a lot of people in attendance at the bond hearings, and have a good solid list of go-to people that can talk really and truly about how it is that they know the defendant, how it is that the defendant has lived his life, what type of connections that person has to the community, and either the lack of history or to be able to explain the criminal history to the judge. Those things can be tremendously influential, in a way much more so than any lawyer could ever do so, in just standing up and giving, a canned 15-minute presentation to the judge. Those witnesses can really, in a very emotional way, connect with the judge in a way that a lawyer never could. So I hope that that's helpful as you're approaching your bond hearing. If I can help you at all, please don't hesitate. My name again is Ben Sessions. My office number is 470-225-7710. Again, 470-225-7710. Thank you.